Our speaker tonight is Professor Richard Avramenko, who is a member of the Department of Political Science at the University of Wisconsin at Madison, where he is also the director of the Center for the Study of Liberal Democracy and the editor-in-chief of the Political Science Reviewer. At the moment, however, he is the Tim and Stephanie Busch Family visiting professor at the University of Notre Dame while he is on sabbatical from Wisconsin. He is the author of many books, including Courage, the Politics of Life and Limb, Dostoevsky's Political Philosophy, and Aristocratic Souls in Democratic Time. His teaching is equally narrowly focused. He teaches seminars on Plato, Aristotle, Nietzsche, Heidegger, Tocqueville, politics and literature, political economy, and conservative political thought. I deeply regret to say that he is an ardent fan of the New York Yankees. Nevertheless, as testament to our commitment to diversity, we have still invited him to this lecture series. He's currently working on an article with the uplifting title of The Politics of Suicide, Miasma and Catharmos in Plato's Political Thought. And tonight he will be speaking to us about Tocqueville, law, and the high priests of democracy. So I hope you will join me in welcoming Professor Avramenko. Thank you.
Well, thank you, Professor Khan, who I understand is a Mets fan. And it sucks to be you this year. The Yankees game starts in 1 minute, I'll have you know. Well, good evening, and also let me start by thanking Professor Khan and the Benton Center for the invitation to speak this evening. I've never been to Boulder before, and I'm in awe of its natural beauty. It looks like an amazing place to live, and I see some faculty houses up there on the side of that hill, I'm sure. My talk today is called Tocqueville, Law and the High Priest of Democracy, and it's a talk about democracy and what Tocqueville calls the esprit légiste. Now, this is a talk about lawyers. And any talk about lawyers probably should begin with a derisive joke about lawyers. But before I do that, are there any lawyers in the room? Excellent. So I was thinking I'd start with an old joke that we all know. How do you stop a lawyer from drowning? But then I started thinking, you know what? Let's not do that tonight. This inclination, I think, to speak derisively about lawyers and to generally disrespect lawyers has not always been the norm in America. For example, the Committee of Five who drafted the US Declaration of Independence, 4 were lawyers: John Adams, Robert Livingston, Roger Sherman, and Thomas Jefferson. Ben Franklin was the odd man out. He was a printer from Philadelphia. More than half the 56 signatories of the Declaration of Independence were lawyers. The Committee of Detail, who penned the sort of final draft of the Constitution, John Rutledge of South Carolina, Edmund Randolph of Virginia, Oliver Ellsworth of Connecticut, James Wilson of Pennsylvania, all lawyers or legal scholars, which is a distinction that I'm going to make coming up in this talk. The odd man out there was Nathaniel Gorham, who was a merchant. 35 of the 55 delegates who attended the Constitutional Convention in 1787 were lawyers or had legal training. Of the 39 signers of the Constitution, more than half were lawyers. James Kent in 1794, in his first lecture as the professor of law at Columbia University, said this: lawyers in a free country should have all the requisites of Quintilian's orator. They should be of irreproachable virtue and goodness. They should be well read in the whole circle of the arts and sciences. They should be fit for the administration of public affairs and to govern the Commonwealth by their counsels, establish it by their laws, and correct it by their examples. Exactly how we talk about lawyers today. Simon Greenleaf, on his 1834 installation as a professor of law, which is a newly created position, there wasn't one before, at Harvard, said this: in later days, when the integrity of that charter had been invaded, its spirit violated, and its language perverted, to whom have all eyes been imploringly directed for its preservation? To the living and honored champions and expounders of constitutional law, lawyers. Now, it's in this spirit that I think you'll find the purpose of my talk today. And I would like to make the case not for lawyers in the practice of law per se, but for the study of the Constitution. Or better put, the study of constitutionalism in America should be at the center of the liberal education. I have heard that the University of Colorado is currently in conversation about their own undergraduate curriculum or lack thereof. And the takeaway of this talk is that con law, or a class on the Bill of Rights, or a specialized class on the First Amendment or on the Second Amendment, should be required in any education that purports to be liberal. That's the takeaway. And I'm going to do this by invoking the thinking of a lawyer much more famous than James Kent or Simon Greenleaf, our good friend Alexis de Tocqueville. For those of you unfamiliar, not Professor Khan, he knows a lot about Tocqueville. For those of you unfamiliar with Tocqueville, he was born in 1805, died in 1859. He was a French aristocrat, a diplomat, a political scientist, a political philosopher, historian, and most importantly for this talk, he was a lawyer. 1831. And his good buddy Gustave de Beaumont, both lawyers working for the French government, sailed to America with the pretext of providing a study of the new penitentiary system over here. And they actually did produce this report, which took them 3 weeks of research to do at the beginning of their research hiatus, which was 9 months. So they spent the next 8 months or so doing what we all do when we have a giant research grant. They gather data. Maybe you know, they sailed into Rhode Island, Newport, Rhode Island. They're supposed to go to New York, and they ended up going to New York, then went up to Sing Sing and did their penitentiary stuff. They went up north to Lake Oneida, and then over to Buffalo, and then to Erie, and then to Cleveland. Is anyone here from Michigan? Yeah, great. So they went up to Detroit and then up to Saginaw, which Tocqueville described as the worst place in the world. And then, what's that? Saginaw. Saginaw is the worst place in the world. And they continued north up there to Mackinac, up and took a boat across, and they went over into God's country, which is Green Bay, Wisconsin. And then after that, they sort of sailed back across, went up into Quebec for a couple of weeks, back down to New York, Philadelphia, Baltimore, out towards Pittsburgh, got and then started traveling by river. This is in 1831, folks. The roads weren't great. So Wheeling, Louisville, Cincinnati. By the way, Tocqueville says of Cincinnati, I stand corrected about Saginaw. Cincinnati is the worst place in the world. And then from Cincinnati on the Ohio River, down the Mississippi, all the way down to New Orleans, and then by stagecoach up through Alabama into Georgia, and eventually back up through DC and to New York and back home. So a big trip. And after all this trip and returning to France, Tocqueville holes up in the attic of his brother's chateau and writes this big fat book called Democracy in America, for which he became famous. Now, before I continue about lawyers, I want to just give you a rough sketch of what he's up to, big picture sketch of what he's up to in the book. The book begins with a philosophical premise. And this premise is that equality as a mode of thinking is spreading through the world. Now, remember, Tocqueville was an aristocrat from the French nobility, or his family was, which means that he emerged from a world in which class-based inequality was the norm. In other words, there was a class of people who were thought to, by birth, be required to rule, or privileged to rule, however you want to look at it. And the majority of people were born to be ruled by birth. This is called an aristocracy. Tocqueville was from the nobility in the French aristocracy. Of course, he was born 16 years after the revolution, during which a decent chunk of the French nobility was guillotined by the radical egalitarian revolutionaries, or as Tocqueville might call them, by democratic souls. Tocqueville himself, I think his grandfather-in-law, the historian was actually guillotined. His father was imprisoned. But so for Tocqueville, this is the big premise. The world is progressing towards universal equality with regard to class. And so he sees equality on the horizon, also with regard to race and gender. And for Tocqueville, as contrary to what we would think, this isn't an unmitigated good. For most moderns, equality is an unmitigated good. And Tocqueville knows we're going to have equality. It is coming, as if ordained by God, he says. But he begins Democracy in America with a statement something like this. We're going to have equality. The question is whether or not we're going to have equality in freedom or equality in servitude. And it's up to us which we're going to have. So when the revolutionaries took over France, one might argue that they came up a little short on the liberty end of things with the genocides and whatnot. They claimed liberty, equality, and fraternity, but they went on a murderous rampage. But it's in America that Tocqueville saw equality or democracy, they're almost synonymous for him, as most progressed. By the way, one of the things he said about Cincinnati, where equality is most progressed, in Cincinnati, they're completely lunatics. They elect their judges, if you can imagine. Yet somehow Americans, despite having progressed the furthest in terms of equality, have somehow preserved the liberties they had shipped over from England. Legal liberties that originated with the Magna Carta. Now, when most Americans read Democracy in America, they think it's a book praising America, and in some ways it certainly is. But Tocqueville, I don't think, wrote the book for Americans. He wrote the book for the French, especially for the elite in France, who were most resistant to the inevitable progress of equality, namely the French nobility. So when you read Democracy in America, as I do, what you'll notice is that Tocqueville's not pointing out innovations in the democratic world that safeguard liberties, but rather, I think he's highlighting remnants of the aristocratic world that the Americans have preserved, even if they have painted over them with a democratic veneer. To wit, everybody knows, anybody who knows anything about Tocqueville, everybody knows about associational life in Tocqueville's work. It was highlighted in Robert Putnam's Bowling Alone book, and there's roughly 1 billion articles on Tocqueville and associations. Very few commentators point out that for Tocqueville, associations are a kind of a contemporary version of medieval guilds. Another billion commentators point out that Americans preserved their liberties with a federal form of government. Very few commentators point out that for Tocqueville, federalism is kind of a modern adaptation of feudal forms of government, with states representing sort of the manorial system and local governors, feudal lords, and things like that. Several commentators, not so many, have pointed out that Tocqueville regards lawyers in America as a crucial democratic remnant safeguarding liberties. Lawyers in America, Tocqueville tells us, are aristocratic because they were public men who were well-read in history, political science, literature, and importantly, the classics of law, like Blackstone's commentaries or even James Kent's commentaries. As Tocqueville says, lawyers in America are the first bulwark against tyranny, especially the tyranny of the majority, because of the character they develop through the study of law. I will unpack that. I saw like, what? Let me unpack that. Lawyers, he says, and I quote him, are naturally strongly opposed to the revolutionary spirit and to the ill-considered passions of democracy. They form a body of privileged intellectual elite with the habits of directing democratic passions. So in short, in Tocqueville's own language, he says, at the bottom of a lawyer's soul, one finds some of the tastes and habits of an aristocracy, close quote. Therefore, he says, the legal body in America is the only aristocratic element which can unforcedly mingle with the elements natural to democracy and combine with them on comfortable and lasting terms. They are from the people. They are not lawyers by birth. So like a French aristocrat, Tocqueville is saying, the American lawyer has a kind of authority in the eyes of the American people. She's one of the people, but she stands out because of how she thinks. The lawyer's mind, Tocqueville tells us, is formed from the study of the law of precedence. In other words, the way the lawyer thinks about today is formed by her understanding of the past, inextricably. That's the hallmark of the aristocratic mind. So Alexis de Tocqueville, for example, it's de Tocqueville, because his great, I don't know how many great grandfather fought beside William the Conqueror at the Battle of Hastings. And for his efforts at that battle, he was granted certain rights, manorial rights around the village of Tocqueville, which is in Normandy. And so his identity and his position in the world is bound up with the past. That's the aristocratic way. For the American lawyer, whose mind has been shaped by the law of precedence, he has a particular kind of authority because these laws are widely believed to have been derived from the will of the people. Like the feudal lord of the ancient regime, Tocqueville sees the lawyer, the Anglo-American lawyer, as one having moral authority. The first thing a lawyer / aristocrat will do in America, Tocqueville tells us, is look back and try to establish regularity with the past. The American lawyer's authority, Tocqueville tells us, is a whole lot like the authority of a Catholic priest. The authority a Catholic priest would have back in the old days in the feudal world. Let me read a key passage from Democracy in America for you. French written laws are often hard to understand, but everyone can read them. Whereas nothing can be more obscure and out of reach of the common man than a law founded on precedent. Where lawyers are absolutely needed, as in England and the United States, and their professional knowledge is held in high esteem, they become increasingly separated from the people, forming something like a class apart. A French lawyer is just a man of learning, but an English or American lawyer is something like the Egyptian priests, being, as they were, the only interpreter of an occult science. The Catholic priest, as every, how many Catholics in the room? We have any Catholics in the room? Good. The Catholic priest at Pepperdine, interesting. The Catholic priest, as every Catholic in the room probably knows, derives his authority from the past. Through the sacrament of holy orders, the priest is connected with the past. For those of you who don't know, there's a genealogy in the sacrament. Every Catholic priest can trace his authority back to St. Peter and Christ. There's a connection. Once ordained, the priest then becomes an interpreter of an occult science, both trained and given the authority to perform other sacraments such as communion. If I can borrow a paraphrase from the passage I just read from Tocqueville, it'd be something like this: nothing could be more obscure and out of reach of the common man than the authority and wherewithal to transubstantiate bread and wine into the blood and body of Christ. I gave this talk not long ago in Alabama, and I asked the only Catholic student in the room, like, you've been to Mass a lot, and you have been to Mass a lot, you know the rituals, yeah. What if the priest is sick and he says, can you come up and celebrate the Mass? I said, no, I can't do that. Well, why not? Because I don't have the authority to do it. But you know every single move. Yeah, I know, but I can't do it. This is what I'm getting at here. So I know it's a kind of strange turn in the talk to compare lawyers to priests, but let me return to the main thrust of the talk now. It's about what Tocqueville calls the esprit légiste. So, I've been talking to you mainly so far about the légiste, and Professor Kahn and I were talking at dinner last night about this. For those of you who speak French, you might be thinking, hey, isn't lawyer avocat or notaire? Yeah, that's true. You're not wrong. Avocat is lawyer. Légiste should probably be translated as a jurist, or one who knows and studies the law. And so for Tocqueville, what's important is not necessarily what the lawyer does with her knowledge of the law, but that the lawyer's mind has been shaped by the study of law, the law of precedent. And Tocqueville, I think, is suggesting that to study the law, therefore, involves one with esprit, as he uses this expression quite a few times, the esprit légiste. Perhaps another way to put this is the study of law as a légiste or as a jurist is to open one's mind to a particular spirit. Well, what might this mean? I promised you I would mention gin tonight in this talk. What is spirit? Well, gin. We talk about spirits when we talk about gin and whiskey. We talk about moods of spirit. Someone can be in high spirits. We mean it to mean enthusiasm, like when we talk about a spirited steed, a horse, highly spirited. We speak of ghosts, of the dead as spirits. Of course, Christians will also think of the Holy Spirit, third person of the Trinity. But when Tocqueville uses this language of esprit, keep in mind, Tocqueville read his Montesquieu. And in 1748, Montesquieu, who was a big influence on Tocqueville, wrote his famous book called The Spirit of the Laws. That is the Esprit des Lois. 1806, G.W.F. Hegel wrote his Phenomenology of Spirit, which is Geist in German. So what I'm suggesting is that for Tocqueville, law is not just a catalog of rules that regulate human behavior. Like the Holy Spirit, the law is a kind of mysterious force that descends from on high or for somewhere and bestows the high priest, that is the légistes, les légistes, with gifts and powers. So then lawyers, for I think in Tocqueville's understanding, are then analogous to the priestly class of the nobility. Recall, noble families provided their local parishes, not only with warriors, but also with priests. In a footnote, in the Old Regime and Revolution, Tocqueville talks about how Roman law came to replace Germanic law. He says that at the end of the Middle Ages, Roman law became the chief and almost only study of German jurists. They applied Roman law to anything that seemed to resemble it in German institutions, to anything that had any distinct analogy with Justinian's law code. They thus introduced a new spirit. I'm quoting from Tocqueville. They thus introduced a new spirit, a nouvel esprit in Germany, new practices into the national legislation. German law was no longer recognized. It was replaced by a je ne sais quoi, he says, which is still Germanic by name, but Roman in fact. So Tocqueville calls it a new spirit, though he's not really sure what to call it at that point. He calls it a je ne sais quoi, I don't know what. That's what he calls it, a spirit. And this new spirit sort of descended on the German peoples, he said made German society worse, especially for the peasants, many of whom had up till then managed to keep all or part of their liberties and property. But this new spirit brought Roman laws of slavery and introduced all the legal necessities to justify serfdom. Alongside a ruler, I quote him here from the same passage, alongside a ruler who's violating the law, it's very rare not to see a legiste appear who is sure that nothing could be more legitimate and who proves academically that the violation was just and that the oppressed were in the wrong. So lawyers, for Tocqueville, being something like Egyptian high priests, interpreters of an occult science, lawyers for Tocqueville must be able to judge or discern the goodness of the spirit descending on our polity. And so for Tocqueville, the legiste is doing her job when she's able to discriminate between an evil spirit that will abrogate our liberties and a good spirit that will preserve these liberties. Also an occult science. And this is an art that needs to be taught. An art that teaches liberty. It's called the liberal arts. Now, what Tocqueville saw in America then was a legal spirit with the lawyer speaking a particular language of this spirit. This is in the opening pages of Democracy in America. He says the language was present, and you read it, you think, yeah, they all spoke English because they're from England. But it's not what he says. He says they spoke the language of rights. And the spirit that descended on the shores of the New World was therefore one of liberties. And for Tocqueville, this isn't just another serendipitous fact that he finds in the northern states. As an aside, I don't know if I could step out of the camera here yet. As an aside, he said, you can find the same spirit of liberty in the forest in America with the indigenous peoples. They were aristocrats through and through. Lovers of liberty with no equality. So the importance of judicial language for American society for Tocqueville is crucial. So fluency in this judicial language, or the language of rights, he says, might be out of the reach of the commoner, because remember, jurists are like priests who have this sort of occult knowledge of the law of precedence, or law based on precedent. The spirit of the language is not. So the language, we will not speak the language specifically, but the spirit is not out of reach. And this is why Tocqueville claims that no one should imagine that in the United States, a legalistic spirit is confined strictly to the precincts of the courts. It extends far beyond them. The language is brought to the lay people through participation in local politics, civil courts, the jury system, and especially by taking classes on constitutional law offered by the Benson Center at the University of Colorado, Boulder. If I can encourage any kind of curriculum that ought to be required of all undergraduates as part of the grad requirements. So this is my claim and my conclusion. When you study American constitutionalism, and in particular the Bill of Rights, it's not the particulars of the law, though these are very important, but rather the practice or the habituation of a particular mode of thinking. We could call it the juridical mode, if you want. It's a mode of thinking that brings the wisdom and the authority of the past It actually brings a certain acceptance of authority, which I think is a problem we're dealing with right now. It brings the wisdom and authority of the past to bear on particular problems of the present, with the mind's eye fixed on how this will play out in the future. Simply put, this is a virtue called foresight. And if you you spread a layer of ethics over foresight, it becomes a virtue called judgment, both of which I think should be at the heart of liberal education. And I think Tocqueville recognized that. I'm open to questions.
Thank you. Thank you very much. I have loads of questions and remarks, none of which I will voice at this present moment. And so we will be taking questions both from our live audience and from our online audience. But I think we will start with one from the live audience. So if someone would like to raise a hand, I will then have the honor of calling upon you. Anybody want to be first? Yes.
Sir.
Do you think that Tocqueville had such an interest or even faith in lawyers because he saw the progress of egalitarianism as a long process of secularization of Christianity?
The lawyers and the sort of spiritual angle that I was giving on lawyers, did Tocqueville value them because he saw a decline in a rise in secularism? I don't think Tocqueville actually saw a rise in secularism. Americans were very religious for Tocqueville and surprisingly religious for Tocqueville. His trip to Canada proved, the Quebecers were really, really religious. But we could bring that up to the point now. The problem I think that Tocqueville sees with egalitarianism or democracy, he kind of uses the language of materialism, right? So it's that which we aim for in our average everyday lives is material goods. And when we aim the good at which we aim is material goods, then the standard by which we measure the good life is how much we have vis-a-vis other people. And so the sort of driving force in egalitarian times by materialism is envy. And so envy becomes this sort of subterranean force with democratic souls that sort of informs them and informs their actions in a bad way for Tocqueville. At dinner tonight, I'm going to ask Professor Kahn where I got this passage from Tocqueville. Tocqueville said at one point, human beings have an incredible capacity to suffer, so long as they do it equally. If you're suffering and other people are not, the problem of envy will arise. And when other people are not suffering, living up there on that hill, we might also be inspired to envy and want to drag them down from that. So insofar as, secularization is sort of determined by materialism, I think he would probably agree with that. And, for things like, seizing of people's property. So property rights are sort of part and parcel of this legal spirit that Tocqueville thinks is valuable in democratic times. So yes, lawyers will help us prevent the illnesses of secularism or materialism. Yeah.
Yes, Dan.
Thanks for the talk. So, of course, for Tocqueville, as we know, democracy is not an unalloyed good, and in particular, it's worried about the tyranny of the majority. Very good. It's fairly clear to me why he can speak in the language of rights would safeguard, would be a bulwark against the tyranny of the majority. But it's unclear to me why Tocqueville puts lawyers only on that side rather than on both sides. Since, as you say, the founders were almost all lawyers, and some of them were more or less in favor of those sorts of anti-democratic protection.
Yeah, so coming back to my opening salvo, some lawyers are scum too, right? Not all lawyers are going to be, bulwarks against tyranny. I think that's the gist of the question. So one of the things I'm trying to do here is to separate out the jurist from the lawyer, right? So I don't think Tocqueville could have imagined whatever the lawyer's name on The Simpsons is. Remember that? You know, he's like this crazy ambulance chaser, terrible, terrible, terrible character. What I'm suggesting and what I think Tocqueville saw here is a certain habituation of the mind. One of the central problems in democratic times, as Tocqueville sees it, is what I call a contraction of temporal horizons. In other words, you can live in the moment in democracy, and you're kind of encouraged to live in the moment. Tocqueville, being from the French nobility, his whole identity is bound up with this really distant past event. And there's decent neurological studies on this right now, that people who are practiced thinking into the past, studying of history, or in this case, the study of the law, looking back at the history of a particular constitutional amendment, for example, develop the capacity to see into the future. The Mitchell marshmallow experiment was sort of testing this theory. But how could we, I mean, it is never good in anywhere to have contracted temporal horizon. Like, I'm going to spend all my money today at the casino. Well, I might win, but let's say something less good than a casino. There's not very many things worse than a casino. But then I forget about my kid's 529 account, right? I need to think at least 16 years into the future for one of them, and 10 years, you know, I need to have at least some expanded temporal horizons. I need to have foresight, right? And so what Tocqueville sees as a recurring problem in democratic times is a contraction of both hindsight and foresight, both of which are virtues. And so one of the ways, so I come back to lawyers are just one of the modes that we might be able to rehearse habits of mind that sort of naturally lead us to have these expanded temporal horizons. It's an argument we could make for environmental causes. If you just don't have any sense of the future, no foresight whatsoever, just when you're done with the paint, dump it down the storm drain. Who cares what's going to happen to it in 3 days? It goes into the lake over there, right? That's just really short-sighted. Other mechanisms besides the study of law, it's the study of history, as Tocqueville understood the study of history. It was very important. Study the classics, very important. He talked, likewise, long-term projects for the state. Like, I read this one passage in Tocqueville when he says the state should really have these long-term, I said, yes, the Mars mission, thinking like 10 years into the future, get people excited about 10 years into the future, thinking into the future. Thinking the future is very good. It's looking into the past that inculcates the habits, like neurologically, of having these expanded horizons. So lawyers are good for that. And that's not the lawyer, sorry, the study of law, which coincidentally produces some lawyers. And when I say that part of your curriculum should be the study of constitutional law, you know, please don't produce more lawyers, right? Produce good citizens. You know, teach them to use the language of rights, which is foresight layered over with ethics, which we can call good judgment, good democratic judgment. Yeah. Oh, sorry. Yes, there was.
I just have a lot of thoughts. I do kind of have a question, but thinking about this, what you're saying in terms of the hyper present and the hyper mediation, and thinking about language and how much it's changing, and we're studying the law. I actually have a JD, but I do legal theory and I'm applying it to a PhD right now. But just thinking about in this moment where language is constantly shifting, how do we deal with that in terms of our study of the law? Because that's a tension I see with this logic of the past precedent. And then also I'm thinking about this tyranny of the expert and how much the lawyer has changed in terms of not really having this liberal arts education, not having this classical understanding of history and things like that due to Taylorization. And so they're no longer really this bulwark against tyranny and authority, right? It's this illusion.
Yeah, let me start with the second one first. Yeah, lawyers, they're lawyers now, not jurists. Right. And so this is a distinction that I think is important for what I'm trying to do here. And what Tocqueville, he simply couldn't have imagined billboards that we see, like hit by a truck, call us, you know, that kind of thing. This is, you know, the practice of law as it's would for Tocqueville just be vulgar. The first question on language, coincidentally, the book I'm writing on Tocqueville right now is a chapter on language, which in the article version of it is published. I'm happy to send that to you. It's on Tocqueville and democratic language. And he was very concerned with shifting meanings of words. And that's what democratic language does. For example, when I was coming here in the Uber, there was a tanker truck in front of me and it said inflammable on the back. And I was kind of chuckling to myself, run into it or not? Is it flammable or inflammable? And Tocqueville would have looked at it like, that's a problem with democracy, imprecision in the use of language. And even worse was what he saw as revolutionary language, where you could just make up the meaning of words. Democracy more settled in their use of language, but there's always these novel words. Rope walkers are called funambulists, he says in this one passage on language. So it is a problem it is a problem in democracy. And I've never actually thought about putting it together. So it's a very helpful question on language and the law. I think that might actually lend itself to this sort of occult science that lawyers have, right? So that we can look back and say, well, what was the original intention of the founders, right, when they drafted this amendment, for example? Because the words we have, they might not mean flammable, inflammable, who knows? It changes over time. And so there's a sort of art of interpreting language as it changes over time. For Tocqueville, he'd rather they never changed. The language never changed. And it sort of bears itself out in Quebec as well. Quebecers are quite resistant to the infusion of Anglo words. Like in France, what do we say? Le weekend? Le weekend, in Quebec, it's le fin de semaine. Right, and they've resisted the imposition of these English words into the language in Quebec for similar reasons that Tocqueville. There's a kind of consistency with the past, and he actually mentions the word tie, like size, like what size is your shirt? What size is your shirt? The tie was this. It was the tax, this hated tax that led to the revolution. Right. And when he goes to Quebec, he said, they've completely forgotten this word. It just simply means like, what size is your hat? Yeah, sir. Yeah, or was there?
Thank you. So that leads me to another question about culture. I guess I have two questions. My first one was, it seems to me that there's also kind of a critique. It seems to me a whole lot of time into it, because when he's talking about democracy in America, he's also criticizing America. So I'd like to hear a little bit more about maybe his view of the downside of high priest materialism, essentially, because he talks about how people in the United States buy homes always with this purposive mentality that we see also at Keynes. This idea that you don't have any time to enjoy anything because you're always planning for the next thing. You sell your house right as the trees come into bearing, right? And it seems to me that there should be also embedded critique in how the high priest would therefore, in this context, lead us down that path. The question was, by virtue of their historical embeddedness into precedent, they are kind of preservers of culture. We might say the United States probably suffers more than any other country from a lack of that, especially now. And since lawyers clearly aren't taking that up, do you have a personal opinion about what sector of society in the United States might actually take that help?
If lawyers aren't good, our lawyers aren't doing it, who's doing it now? Yeah, I don't know, con law professors. But let's say it's the critique. So yeah, I mean, he's praising America because it's not horrible. Maybe one way of putting it. Look, I mean, they've taken democracy as far as anyone has taken it, yet they've somehow preserved their liberties. They have this revolutionary spirit, even though there was a revolution, didn't happen like it happened in France. He's got all kinds of nasty things to say about Americans. For example, they pick their teeth at the dinner table and he won't eat with them. Their music is horrible. Their literature is wretched. Like you said, they're materialist, sell their house just as they got the roof on and the orchards are coming into bearing. But think of what it could be like if they didn't have all these other things in place. It would be really bad. And so he's pointing out what these bulwarks are that might be adopted or at least considered in analogous forms in France and Europe. So yeah, I think democracy is both praise and warning. He doesn't have great things to say about women in America. He's got great things to say about women in America, but he's got not great things to say about women in America. They are the, they get the mores, and America's great because of their women, but he's not attracted to them. And that's the aristocratic edge. So it is full of critique. I would like also to add, in case anyone else wants to ask the question, volume 1, part 2, chapter 10, longest chapter in the entire book on the 3 races in America. He recognizes the juggernaut that is democracy is crushing the other 2 races in America, the indigenous and the African Americans. There's like this little vignette in it when he sees like what it might be in America. But unless these other occupants of the North American continent somehow find a way to participate in this historical reality, it's sort of a Hegelian vision he's got of equality is coming. It's not even someone's out there pushing it, it's just rolling through history. Unless they find a way to sort of get on that train, they too are going to find themselves in the same position as the French nobility, which is doomed. He says the same thing about the French Canadians. Although they're wonderful, they're doomed. And I mean, they're still there. But the French culture, the part of the culture that he liked, is long gone. There's 98% participation in, 98% of people in Quebec went to Mass when he was there. It's down to about 11% now in just about 45 years. So there is a, it's a running critique of America. He says another passage, which I don't bring into this, and probably I won't because it sort of contradicts everything I want to say. He says, the Spaniards sicked their dogs on the indigenous people. The Americans sicked their lawyers on them. And the damage was far greater. So, I mean, there is certainly a running critique in it. And so what I'm trying to say, and it speaks to Dan's question as well, it's not like it's the lawyers that are going to save us. It's not the lawyers going to say, I'm sure they're going to do a great job. It's not the lawyer, it's just sort of one part of these sort of manifold things that he sees in America that can somehow provide or mitigate the worst part of the democratic impulses of the democratic soul, as I call it, which is sort of riddled with envy and materialism. Did I get both your questions there?
Yeah, I just don't put a whole lot of faith in the influence and impact of professors.
Oh, well.
Professor Avramenko was our sub.
Yeah, okay, so how about you teach the classics then? Right. So like there's a way of teaching history. There's the classic literature. They said it's like about teaching the classics, like the Romans and the Greeks. You read this stuff, they say nothing. It's just this empty, silly, vacuous stories, but they say it beautifully. Why? Because of back to the language, because their grammar is perfect. The article I wrote is called The Grammar of Indifference. To sort of paraphrase something that Tocqueville is doing. The grammar is perfect. And so what you want to teach when you're, if not con law, teach them to care about the particulars of language and how they put it together. Why? Because that's, who here likes the Oxford comma? I don't care about the Oxford comma, but I make them use it. Why? Because then they start asking into, well, what other grammatical things do I have to learn that are like these archaic things that he's going to dock me 1 point for? Split infinitives, that's 2 points off any paper submitted to me. Now, what's a split infinitive? Look it up, go figure out the grammar and go back and look at, so perfection in grammar, right? There's a sort of, so there's other ways of doing this, teaching the classics, teaching history, and it's, sort of like the heroic model of history.
Against Esperanto.
Yeah, no, for sure. Yes, I hadn't thought of that, but yeah, for sure. Yes. No Esperanto for Tocqueville.
That's the biggest thing, but he shares that contempt. So that makes sense. Preservation of grammar.
Yeah, there are other ways. So just the lawyers are, I say lawyers, I should just say like the esprit légiste, right? So it's teaching the esprit légiste. It's not teaching people to be lawyers, right? But the juridical mode of thinking. So if, for example, and I've written an example out here. So in my center, I try as often as I can to get our postdocs to teach a class on the First Amendment, a whole semester on the First Amendment. usually just on the free speech clause. But they feel free to expand it. The First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievances. The law of the land says the government shall not abridge freedom of speech. Right? Pretty simple, but there's just like a whole occult science to figure out what exactly that means, and it develops over time. So when we do a session for high school principals on free speech in Wisconsin high schools, when I tell the principals, you come to this session, I'll teach you how to not get sued. And I say, if you're not getting sued, maybe you're not violating people's rights, it's a win-win. And so then they start walking through, we look at the Tinker case from 1969, Tinker v. Des Moines. This is the one where the student in 1965, Mary Beth Tinker, wants to wear a black armband to protest the Vietnam War. The principal says, get out, I'll suspend you, blah, blah, blah. Brought up his first case, they lost. The court says, people's rights don't end at the schoolyard gates. Settled. Now we know what they mean by abridging free speech, right? Wrong, because then there's the next case when the court comes back and says, well, actually, if it's going to be, well, you get the disruption test from the Tinker case. But so you sort of, then the next case, 1980, the next case, 1986, when they said, actually, school administrators can limit your speech if it's vulgar and lewd. The famous bong hits for Jesus case. Right, so as a school parade, the student goes across the street off school property, hangs a big banner up, says bong hits for Jesus. Principal says, take it down or you're suspended. Brings it up, court rules, actually, the school can limit speech if it's advocating the use of illegal drugs or illegal action. So like this is the occult science, right? So you have to sort of educate yourself in it. Is it the First Amendment in high schools that matters? For me, yeah, it matters, but it's the mode of thinking that says, well, how did this unfold? It's a nuanced way of thinking about what is kind of just an arcane expression, abridging free speech. If it was codified and this was laid out in the law, all that stuff is not laid out. This is just in court decisions. And so then you get these jurists or these juridical minds who start throwing these cases at you. Tinker v. Des Moines, Hazelwood v. Kuhlmeyer. Like they just throw all these things out and if you're a foreigner like me, you say, I don't know what you're talking about. But it's good law. It's a mode of thinking that Tocqueville is suggesting is good to mitigate against the sort of free use of language that's meaningless. It's all inflammable, right, for Tocqueville in democracy. Next question. I know I got excited there.
So, I'm not sure this is a question about Tocqueville specifically, but like, does it matter what you discover? So in studying the law, in looking for precedent, is it just about a continuity with the past, or is there a kind of continuity that is better? Like, is there an assessment of like, well, this represents kind of the majority of something. That word is probably not the right one to use in this context, majority, but like, is there like a balance of the evidence suggests that this is the right precedent? Does it matter?
Yeah, I tried.
Or is it really just the mode of thinking?
So I think, that's what I tried to do with the case of the German jurist bringing in Roman law, and it was horrible. It sort of reintroduced slavery back in. There has to be a kind of discernment there as well, right? So foresight, the virtue that I'd like to suggest that comes from this is foresight. That's just too simple, because you could say foresight, if I do this, that'll blow up even more buildings, right? You take past facts and translate them into really horrible things for the future. So foresight in and of its own, not a sort of fully realized virtue that's necessary for any decent polity. So, what Tocqueville is trying to suggest is, and the way I'm sort of presenting it here, is that there is a layer over this sort of, first of all, there's this mode of thinking with expanded temporal horizons, but it's not just for the sake of anything, right? We have to have, well, in his estimation, what tempers that, or what sort of completes that, is this language of rights, which that's when you get the Anglo-American lawyers going back to the Magna Carta, right? So you start with the concept of rights, and then through time, it sort of expands to more and more people, and it is inevitable, he says, it will expand in terms of race and gender as well. The language is there, it's now just a matter of finishing the job. But without that sort of ethical layer painted over the sort of forms, the structure of the mind, then it can go anywhere. So it's not without content for Tocqueville. He is a liberal. His first concern is human freedom. That is the good at which he thinks that we should be aiming in how we construct our institutions and social lives. So it's not contentless.
Well, I'm going to jump in and ask a question and make a comment. So you spoke of lawyers, the aristocrats of democracy, which is something that Tocqueville himself says. And then you added this rather striking analogy, lawyers now as the priests of democracy, which I don't think comes out of the text directly. There's rather a difference between being an aristocrat and being a priest. And then when you talked about the jurist here, part of the way that the founders and so on were jurists with this very broad education, classics, so on and so forth, which made them sound almost like intellectuals. But Tocqueville doesn't much like intellectuals. He talks about them very differently in the old regime. So his ideal lawyer is not his notion of an intellectual, so not a French intellectual. And I'm not sure how that relationship of aristocracy and aristocrat and priest works. There's sort of a lot of potential tensions there.
Yeah.
That's point one. And then very briefly, point two is you mentioned a quote that I was going to mention about, well, next to every would-be despot, you have a lawyer standing next to him saying the law is on your side. Go ahead and do it. Which reminds me a little bit about my predecessor.
I was going to say the Benson Center. I was going to say, welcome, my name is John Easton. Yeah.
And he's thinking, in fact, about Napoleon III and some of the leading jurists of France. We have great respect for his legal minds. So at least the later Tocqueville is perhaps not quite so confident as the earlier Tocqueville was about whether lawyers would really do what he wanted them to do. And this actually, I think, works into your last point. It has to be the right kind of law. Roman law, which is the kind of law Tocqueville learned, is the despot's best friend. It's common law, the kind of law found in America and England, which is the friend of freedom.
Right.
And that's a really important distinction.
The common law or the law precedent. I think that's the language that he uses for it. So on the first, as lawyers and aristocrats. So I mean, they're like Egyptian priests. I know that's not the same as a Catholic priest. But that what I'm trying to suggest there is that as Tocqueville's understanding of the jurist, because the jurist has this sort of occult knowledge that I've tried to describe, like if you're thinking about the First Amendment in America, they have a kind of authority. And I think that's another problem that Tocqueville sees with democracy. It's the erosion of all nodes of authority. And so aristocrats had authority prior to 1789, maybe prior to 1689. They had, for Tocqueville, there was about 150 years where they simply had power but no authority. So it's what is the locus of authority in democratic times? I actually might write my next book on this problem of, so that's what I'm trying to do with the, sort of invoking. I'm at Notre Dame right now. This would have been a more familiar example or analogy to use, like the authority that the priest has to celebrate mass, right? It's just sort of, it's unquestioned, it's historical, and it's just sort of a mode of thinking that's bound up with it. Why does the lawyer have any authority? Why is there any authority when we're obsessed with the dogma of the sovereignty of the people, right? So the dogma of the sovereignty of the people, the locus of authority becomes amorphous, and it turns into the tyranny of the majority, right? So what I'm trying to do with this sort of idea of the jurist as an aristocrat is not that they have sort of, by birth the right to rule, but there's a kind of place of authority that a learned jurist has. And when we teach con law to students, Fourth Amendment stuff, and the students see the kind of power and authority that the law has, in particular vis-a-vis the police. So when the police want to come and approach you, for example, and say, I'd like to have a look in your trunk, can you pop it open? When you have the authority of the law with you, you can say, respectfully, officer, I do not consent to searches. And the policeman, if he knows the law, will say, you got me. There's a kind of authority in the law, so not in the lawyer, but in this mode of thinking. And if the cop says something like, stop filming me, you can then cite this case in Michigan, this case in Ohio, and this Supreme Court case. You are a public official in public doing your duty, and you have no expectation of privacy. Cite the cases, and if you stop me from doing this, I'm going to sue you. The law has authority, even over a potentially despotic administrator. I'm not saying that, where's Alex? No, not a despotic administrator. I regard the police as bureaucrats with guns. I mean, that's what they are. They're bureaucrats with guns enforcing rules. But the law has power over potential despots as well. See what I'm trying to say? Like, so where does the authority lie? And it lies in law. And that's what I think we do by teaching con law to students. We don't want them to become lawyers. We want them to become citizens informed by and respectful to the authority of law. Hopefully, it's good law, not Roman law, right? So there's a judgment call that has to be part of the liberal education, right? It's law with authority that protects your liberties. That would be good. I know we've had someone who hasn't asked a question. Yeah. Yeah. Yes, you. Yeah.
Oh, all right. So America has this cultural inheritance of English law, but like, did Tocqueville have any attachment to like the law of precedent in particular of like, did he have a preference for the like almost occult-like nature of like English law versus French law, or was it more so just like a study of the past in general?
Yeah, so I mean, like we said, he's a French lawyer, and he sings high praises of the Anglo-American legal tradition, which is common law or law based on precedent. So you can take a simple principle like shall not be infringed, and then sort of work through the cases that have led up to a nuancing of this law. So he had great respect for the Anglo-American legal tradition. What I'm trying to suggest is that's just sort of one mode of inculcating these certain habits of mind that are necessary, especially necessary in democratic times. So yes, he's keen on Anglo-American law. He had a lot of conversations with lawyer. As I said, I just presented this in Alabama, and there was one historian at the talk who said, do you know about his trip through Alabama in a stagecoach with an Alabama lawyer? There were 493 lawyers in Alabama at the time that Tocqueville was here, and he met one who in the stagecoach said, oh, it's lawless here. We can just barely do anything. In fact, everything is settled by knife fights. Look at all the scars on my head. And he showed him 3 deep scars on his head from knife fights that the lawyer had been in. That doesn't actually help my case, but it's quite funny. But that was sort of like on the frontier. And the point that the lawyer was making, if we can trust the historical accounts, is that the full authority of the Anglo-American tradition hasn't really come out to the frontier in America yet. But it's coming. And that's the sort of, what is the edge of civilization? The edge of civilization for Tocqueville was how far, equality had progressed, and the sort of things, the good and bad things that would come with equality. And so there's certain, when he gets into the American South, there's no equality. It's aristocratic. Of all the worst parts of aristocracy, including slavery. But yes, lawyers are good. Anglo-American lawyers. I mean, it would be really interesting to see Tocqueville in law school in like Harvard or something like that. That might have been really interesting. You have to do gets a grant to study law at Columbia for 6 months or something. Kind of fun project. Is there some online questions that you wanted to bring up, or?
Oddly enough, no, apparently our online audience has not been very productive with questions. Normally we have quite a few, but not today. So
well, usually somebody asks the punchline to the joke too, but
please do.
Yeah. So if someone wants to ask that later, I'll do that at the end. It's like, yeah.
I was going to ask one. You mean any point in history when language was fixed and perfect in the way that you described?
Sure. Not me, Tocqueville. 13th century France. That was like the time was, it was fixed then. We weren't innovating language. We didn't call our children pawns of love, things like that. Like,
Certainly not before printing presses.
The ancient world. The classic text then would be, maybe Tocqueville would turn to that. But the grammar
Tests
for,
they're also not consistent.
Just because Tocqueville said so, I
Yeah.
do regret to say it, doesn't mean it's true. So he does imagine an ideal perfection of language in quintillion and so on, of a particular moment. And he thinks that language has changed more slowly in aristocratic times than in democratic times.
certainly.
I have no idea if you can historically make that case. In fact, probably you can't before the printing press. But this is what he imagines to be.
So I'm reminded of a passage from Nietzsche when he said, "Isn't it ironic that when God wanted to become a writer, he had to learn Greek, and then ... and that he didn't learn it better." So the biblical French is much simpler than Attic or Epiconic French.
I guess my point is that there's never been any singular language.
Yeah. So I've got
There's
this.
and that's not to say that you can't also value a certain consistency for communication in the ways in which our reference matter. Because it provides a kind of clarity that other uses don't.
Yeah.
But that's, I don't know if we can link it back to what Taylor was saying before. There's a difference between, say, precedents as forming something consistent over time that we want to read into in order to have foresight, and sort of like, how I put this, a concern about the truth of the matter, and one that's completely unworthy. So let me actually ask the question. If you are valuing the precedents in this way, what happens when the precedence is, as far as we're aware, an immoral one, or a bad law, or something that supports a despot?
Well, hopefully you'd have the capacity to judge or to discern whether this is a good or evil spirit, because I think he does refer to law as spirit. Okay. And I think, my easy answer to that is Tocqueville does have a guiding principle, and it's human freedom. And so there is a metric by which we can judge whether or not the precedent should be brought to bear today. I'm not going to disagree with you that language is shifting, and Tocqueville himself, he says this, and it can cause a lot of confusion. When you get like rapid innovation of language, the kind of language that he uses here is, it's sort of things just kind of get carried away and things are sort of running away. And if there's anything that Tocqueville, from this kind of mindset that Tocqueville has, and remember, I think he has sort of an aristocratic frame of mind, or sort of an old-fashioned frame of mind. He's a conservative, in my opinion. He's a liberal, possibly an aristocratic liberal, that sort of values a regularity of thought, like a predictability of thought. And when Tocqueville gets most agitated, it's when I'll give you two examples, and this might make it into my book, I'm not sure. He uses the language of religious terror religieuse. And once, and it's in Fortnight in the Wilderness, when he's near the second worst place in the world, that's near Saginaw, he's in Michigan. Professor Kahan has a house in Michigan as well. He gets lost in the forest, and so he's utterly alone. And then he starts to notice that when the trees fall, like the old growth trees have fallen, new trees are growing out of it, and sort of temporally speaking, it's completely mixed up. And he says, I felt then a religious terror. He was in an abandoned Catholic church in England, and there were the gravestones in this church that have the dates, the birth and death dates in it, and it's all falling apart. And the sort of the temporal order, or the historical order in the church, right? One, he's alone again, and then he's where the sort of the regularity of the past, present, and the future is all topsy-turvy. I felt religious terror. And so the sort of habits of mind and frame of mind that Tocqueville is saying is helpful as a sort of prophylactic against the excesses of the egalitarian mind are sort of orderly. There's a sort of orderliness of mind, a regularity of mind, a consistency in the mode of thinking that is quite likely can be habituated through the study of law in this way. Also grammar, also history, also, I don't know if he says music anywhere. I don't think he says music. Americans had horrible music too. For Tocqueville, I don't know if that answers the question. It's like, so it's a general frame of mind that he sort of, we need to put up as a barrier against the worst excesses of democracy. And the worst excesses of democracy is genocide.
In fact, just to follow up on that, the reference you made to Tocqueville talking about during the revolution, words suddenly change their meaning. Black becomes white, betraying your parents now becomes a sign of your virtue because you do it in the name of the revolution. We never know very well what Tocqueville read, but this in fact looks like the passage on the island of Corcyra and its civil war from Thucydides' Peloponnesian War, where Thucydides talks at length about this transformation of language under the circumstances of civil war. And quite possibly Tocqueville has just picked this up and applied it to the French Revolution. And this is the danger of allowing language to be infinitely malleable. The aristocratic language preserves stability, exactly the kind of thing that Rick was talking about in terms of precedent and legal historical.
And when you have this sort of historical mishmash, when he uses the language of terror, it is a reference to the terror of the revolution. It can't be otherwise. It's on his mind. Question in the back, yeah.
I just want to mention that more and more friends of my friends are talking and complaining, saying that these days they feel that the law, the legal system is not that fair anymore because they feel like if you're on one side, which is belong to the tribe, that's the word they use, and because of some information divide, and for us, we don't have the knowledge or resource to investigate to see exactly what happened and whether it's true. Like one law has been interpreted in two different ways. Some of them did the same thing, but they are not. And the other people, other group, are having some serious questions. So I just want to find out.
So I don't see. So the law can be applied inconsistently today. Yeah. So one man's protest is another man's insurrection, right? So you can burn Seattle down, not that they don't deserve it. Just kidding. But you can't like have a protest in the Capitol January 6th, the insurrection, however you want to. It's like no charges brought there, charges brought there. But I think a sort of a more interesting part of the question is then the interpretation of the law, right? And so, I mean, this is an ongoing concern with political theorists because we have to interpret texts. So when Tocqueville says something like, I felt religious terror, Professor Kahan and I are probably gonna go for dinner and he'll be like, Rick, you're insane. That is not what he's referring to. He doesn't do that. It's like, well, that's how I interpret the book. And I've got other evidence for it. And we'll have these interpretive differences on the book. And law is the same, right? Interestingly, I've discovered recently tax law is the same. I interpret it this way, the IRS didn't. First in, first out. I didn't know that. Okay. But so like all law is sort of open to interpretation, right? And I think this is a good thing, right? If it's a bad thing, I mean, if it's open, if it's used to abuse people's rights, right? And so, you know, there aren't infinite interpretations of a particular passage in a book. There are finite interpretations of a passage in a book. There's finite interpretations of a biblical passage, finite interpretations of a law. I think, I mean, one way we might talk about this in terms of a liberal education is that, isn't it interesting and better that we sit down and talk about the interpretations of a law to try to find out what's the most just way of interpreting the law and applying the law? Seems to me to be a good thing, because the alternative is like fighting it out in the streets.
Well, on that note, that we should all oppose fighting it out in the streets, I think we've come to the end of our time now. So thank you very much again, Professor.
Thank you. Good question.